So, here are the objectives for the lecture for this week. I want to give you an overview, a kind of eagle's eye view of internal market law so that you are introduced to the whole of this topic. And this should help you to prepare for workshops 2 and 3. And I also want to begin to prepare you to think about how you might apply examples from internal market law in essay questions and in problem questions. So here is the plan for the lecture. We're going to start with a simple introduction and then a more detailed one. And we're going to make that a kind of active learning for you. So I want you to think about some questions that you might have about the internal market or internal market law. Then we're going to turn to some historical context, and we're going to start to make links to earlier lectures and earlier topics in the module. One of the things about this module is that lots of the things that you will meet in this module, lots of the elements that you'll meet in this module are interconnected, and the same example might come up in more than one place. So we're going to start, now that we're quite a long way through the lecture program, we're going to start making links to earlier lectures and topics, or more links. Then we're going to turn to thinking about the internal market as a legal construct. And finally, we're going to start talking about the internal market and how it relates to other values. So I'd like to start with this really simple explanation of the single market. The hyperlink is here so that you can watch it. We're just going to listen to it in a second. When we're listening to this, when you're watching this, just bear in mind that, of course, the maps in this YouTube video will be out of date after the end of this year because of the Brexit process. And what I want you to do while you're listening or watching you could pause this and watch this on YouTube, or you could just listen to it here. It's probably easier if you pause and watch it on YouTube. I want you to start making a list of questions, a short list of questions that you have about the single market. So they could be really easy questions like, what is it? Or they could be this kind of question here that might be prompted by the YouTube video. So try to make your learning active and start making a list of questions that you have about the single market. Okay, let's listen to Sticky Tricky Law on the subject.
Welcome to the second of the short.
Oh, no, that's the wrong one. Let's listen to Sticky Tricky Law on the subject.
It's Sticky Tricky Law. The European single market consists of all the EU member states. Other countries have access to it, but they must follow the rules in order to do so. As a consequence of Brexit, there's still a question as to the UK's future relationship with and access to the single market. The European single market aims to be an area without borders or barriers to internal trade. It is built on the 4 fundamental freedoms: the free movement of goods, the free movement of people, the free movement of capital, and the free movement of services. The free movement of goods means that products should not be faced with barriers when crossing borders between countries in the single market. For example, quotas on the amount of products as well as customs duties or tariffs are prohibited. The free movement of people means that those who are entitled under the EU treaties have the right to travel and move freely between the member states. Subject to certain conditions under EU law, EU citizens and their families have the right to work and reside anywhere in the EU. The free movement of capital refers to the easier movement of money for investment and trade. The free movement of services means that companies or professionals have the right to establish themselves and to offer their services throughout the EU. Member states must remove barriers to free movement. This includes national laws which could act as barriers. For example, member states cannot tax their own products more favourably than those from another EU country. Exceptions to free movement for national laws are only allowed on certain grounds, such as national security, public policy, or public health. The laws and rules of the single market are set by the EU member states, acting through the European Council and the European Parliament, and they are based on what was agreed in the EU treaties. They decide on how the single market is shaped and how it works.
So, I hope you've now got a list of questions, and what you need to do next is to pause this video and watch Michael Dougan, who's a professor of European law at the University of Liverpool, in this YouTube video from October 2016 on the subject of the internal market. And while you're listening to Michael, see if you can answer the questions that you have written down, and also answer the questions on the slide, pausing Michael Dougan's video and writing your answers as you go. So these questions are some factual questions like what is the difference between a tariff and a non-tariff barrier? Some more evaluative questions like which is harder to deal with and why is that the case? Some questions in terms of interpreting Michael Dougan's argument. Some questions in terms of different categories like limited harmonisation and mutual recognition, and we'll come back to these later in the lecture, but it's really good to try to answer them just from the Michael Dougan YouTube video to begin with. And then there are some questions about what the EU needs to create the single market, how long has it taken the EU to reach a system of mutual trust, is internal market law ever finished? Is it ever a finished project? And what are the key differences between EU law on the one hand and ordinary international trade agreements, bilateral or multilateral free trade agreements? So I want you to pause this video now and then watch the Michael Dougan video and write down your answers to these questions from that video. When you've done that, if you're not sure of any of the answers, please do come and check in with me in my office hour, which needs to be pre-booked, or at my virtual water cooler any weekday at 10:30. There's no need to pre-book for that, just turn up. If for some reason I'm not there, send me an email and we'll figure out a good time to meet. And if you have any remaining questions, and also to provide depth and enough detail for your workshop and your tutorials, as well as, of course, for the assessment, you need to have a look at the relevant chapter in a good textbook. So, once you've done all of that, you'll have a good idea of what the internal market is. So now you have a good idea of what the internal market is, let's take a step back and look at some historical context. And for this, I want to draw on a paper written by Bojan Bugaric, who lectured you the other week, published in the LSE Working Paper series. And the paper is called Europe Against the Left. And I've put the hyperlink to the paper there so you can read it for yourself. But I'm using this paper to structure the kind of historical overview that I'm giving you here. So what happened when the original treaties were negotiated, the original settlement in the 1950s, represents a kind of compromise, which is to decouple, to disentangle, to detach economic integration from issues to do with social or welfare protection. And if you think about what was happening in the 1950s in Europe, particularly Western Europe, this was when welfare states were being established. So economic integration was constitutionalized, if you like, in the original treaties in a kind of economic constitution for the original member states. The social, that side of what was happening, was put onto a separate track and stayed mainly national. So when you have accounts that argue that the treaties of Rome, or as have been amended, represent an overwhelming victory of neoliberalism over the French attempt to institutionalize a more socially aware, a more regulated Europe, that is overlooked. The fact that actually the more regulated, the more welfare attuned approach was there right from the very beginning in the politics. And in reality, both Christian Democrats and Social Democrats, for different reasons, were strong supporters of the welfare state. So both camps had their own reasons not to transfer social policy to the European level. So what happened instead was the original founding treaties, and this continues to this day, represented a compromise between two different visions of European integration. On the one hand, we find German ordo liberals, strongly represented in the German negotiating delegation, favouring economic freedoms as the key instrument of integration. while on the other hand, both Christian Democrats and Social Democrats embraced a vision of regulated capitalism at home, combined with open trade on the European level. And this is known as the Smith abroad, Keynes at home compromise. So the idea is that you would have Smithian economics inspiring your international trade relations, Smith abroad, but you would have Keynesian approaches and Keynesian economic approaches inspiring your domestic economic and political settlement and welfare system. So that's how the European Union was established, on the basis of that compromise that suited both sides. And then over the first 2 decades of the existence of the EEC, it didn't really evolve into much more than a customs union. And so that meant that the national systems of social protection could expand rapidly. There was no challenge to the different national settlements in terms of social regulatory values. And that meant that the European Economic Constitution, in its very simple early form, could easily coexist with nationally based systems of social protection and development. So member states could gain from the advantages of being part of the bigger common market. At the same time, they were able to continue with the post-war state-led development of their national welfare states. But what that meant, of course, was that the EU could not benefit from the economies of scale implicit in a single market, as opposed to a much more simple free trade area or customs union. The big prize, the real prize here, is the potential of creating a bigger trading space and the economic development and the prosperity implied in that bigger trading space. So when we come to the 1980s, there is a real move in the European Union to seek to create the single market, to move beyond these rather simpler arrangements to something more ambitious, so that the economies of scale and associated economic development and greater prosperity could be achieved by the member states. And of course, by this time, the EEC has expanded in size in terms of its numbers of member states as well. So it is a big economic space that we're talking about, and by now it's an even bigger economic space. So through the 1970s, we had a decade of stagnation, what's known as Eurosclerosis. Decision-making couldn't go ahead because Council had to decide unanimously, and France in particular blocked a lot of legislative reform. After that time, and we had the empty chair policy as well, after that time, European integration gained a new momentum with something called the Single European Act, which is a treaty amendment, and the Maastricht Treaty in particular in 1992. So these revisions of the original treaty were the consequence of a broad political convergence among the key member states at the time, Germany, France, and Britain, and they moved towards the neoliberal goal of creating a single European market. The single market was very much supported by the British government at the time, which is the Thatcher government. So the relaunching of European integration at this point coincided with a major shift in the dominant political ideology in Europe. So the golden age of the Keynesian welfare state came to an end and gave way to a new powerful ideology, pro-market liberalism. And at the same time, in the preceding decades, the Court of Justice of the European Union had been consolidating the key aspects of EU law, its supremacy, its direct effect, these things that you've studied in the electronic workbook and that Francesca touched on in her lectures, and in fact that Bojan also touched on in his lectures, that mean that EU law reaches far into domestic legal systems through relationships mainly of cooperation with domestic courts. So what you will see as we study internal market law is how these constitutional qualities of EU law play out in the context of what we might conceptualize as a clash of values between the market or the neoliberal, so Smith, and the welfare or the social, Keynes. Or you might see that there are other ways of conceptualizing it, like a clash between markets and human rights, or a clash between markets and other values such as human dignity. So what are these strong legal tools? Well, you've studied these already. The EU's competence expanded so that a huge legislative programme could be launched, first creating a single market in products and then moving on to more tricky aspects, especially services, establishment of companies and movement of people, as well as free movement of capital. And the legislative procedures changed at that time so that instead of unanimity in council, which means effective veto and then the legislation just doesn't get adopted, there is qualified majority decision making in council. And in terms of legitimacy, you have a strengthened and increasingly strengthened role of European parliaments, and the European Parliament, and of course some role for domestic parliaments, national parliaments. But most importantly, in terms of these strong legal tools, critically, the Court of Justice established the principles of primacy or supremacy of EU law and the principle that both treaty provisions and directives, and lots of internal market law takes the form of directives, can have direct effect, which means that they can be enforced in national courts and they can be enforced even against measures adopted by national administrations. So there's a good place to stop for the moment. If you need, or when you are ready to give yourself more depth, more information, a good place to look is these chapters in either Craig and de Burke or Barnard and Peers, or there are other high quality EU law textbooks which will give you the history of the internal market just as well. So time for a quick pause and I'll see you in a minute.